USCIS is no longer offering applicants additional opportunities to correct their submissions. They now have the authority to reject a case outright without first asking for more documentation. Hello everyone, welcome back to my channel. I'm Ksenia, and I create content for individuals navigating the family-based immigration journey. I'm not a lawyer. My videos are grounded in publicly available data, my personal journey, and the experiences shared by my viewers. The goal of this channel is to empower you with the confidence to handle this process entirely on your own. In this video, we're discussing the August 5th, 2026 policy update regarding requests for evidence and notices of intent to deny. Under this new directive, USCIS is essentially signaling that they no longer have the time or tolerance for incomplete filings. So, we'll break down this memo in greater detail. But before we dive in, I want to discuss the immigration principle known as the burden of proof. In immigration matters, the burden of proof always falls on the applicant, meaning you, as the person filing, are responsible for presenting your case to USCIS, all forms, all evidence, and all supporting documents that demonstrate your eligibility for the immigration benefit you seek. This is what the second sentence of the policy memo refers to when it states that the burden rests on the petitioner or applicant to establish eligibility for the benefit they are requesting. The initial application represents your first opportunity to present everything to USCIS. Your second opportunity comes in the form of a request for evidence, where USCIS essentially says, okay, you've submitted documents, but something is missing, or we require further information. Now, if after you respond to this RFE, USCIS still finds it insufficient, or you failed to provide the correct documents they requested, and they remain unsatisfied with what you've submitted, they then issue your final opportunity, a notice of intent to deny. This essentially means you still haven't given us everything we need, or we still lack the information to make a decision on your case, so we are moving toward denial. However, this is your last chance to provide us with what we need before we reject your application. So, what this policy memo communicates is that USCIS does not want its officers spending time issuing these RFEs and NOIDs or granting multiple second chances. They can now proceed to deny your case immediately without requesting any additional materials. What they're clarifying is that USCIS has the discretion to issue these RFEs and NOIDs, meaning they have the option to do so, but it is not mandatory in every situation. The key point in this statement is that USCIS can proceed with a direct denial when your application has no legal basis for approval, meaning you were not eligible to file for what you applied for in the first place, or when you fail to provide the required initial evidence. Let's briefly go over what qualifies as initial evidence. Initial evidence includes everything necessary to establish your basic eligibility for the benefit you're seeking. For instance, if you're submitting Form I-130, Petition for Alien Relative, the required initial evidence includes a copy of your marriage certificate to show you're applying for your spouse. You must also establish the petitioner's status in the U.S. within this form, whether they are a U.S. citizen or a lawful permanent resident. You'll need to submit a copy of their U.S. birth certificate, U.S. passport, or green card. You must also provide evidence of your relationship. If you're filing a marriage-based case, or say for Form I-485, the applicant must include a copy of their foreign birth certificate along with a certified translation. And by the way, if you're unsure about the exact checklist of evidence required for each application, you can visit my shop. I'll link it in the description below, and you'll find free cover letters for green card applications, full packets, and other submissions you're sending to USCIS. Those cover letters also serve as checklists for required initial evidence. When USCIS issues an RFE or NOID, it places a complete hold on your entire application until you provide what they've requested. The officer sets your case aside and will not continue processing it, nor any related applications tied to your case, such as your employment authorization. This creates significant delays not only for you as the applicant, but also for USCIS itself. In the past, some applicants would even submit placeholder applications, essentially bare-bones filings without supporting documents or evidence, just to secure their place in line, especially in situations where applicants need to lock in their status or priority date. That is extremely poor advice, sometimes given by both professionals and non-professionals. These placeholder filings, as USCIS states in this memo, will no longer be acceptable. Another crucial element of this policy memo is the timelines. Once USCIS issues an RFE or NOID, they must provide you with a specific period to gather and submit the requested evidence. For an RFE, the maximum allowed timeframe cannot exceed 12 weeks, and for a NOID, it's no more than 30 days. If you examine a typical RFE or NOID letter, you'll see the allotted response time clearly stated, usually at the top. Under this new memo, USCIS is indicating that this will change. An officer will now have the authority to decide how much time you get to respond to an RFE. They could give you as little as 10 days, a month, 2 months, or they could grant the full 12 weeks. As I mentioned in another video, USCIS is increasingly using artificial intelligence to pre-process and handle many cases. For example, the system will scan your submitted packet, identify the form, count all the pages, ensure all boxes are checked correctly, and verify that all necessary information, like your biographical details, name, date of birth, etc., is present. It will also begin scanning through your evidence and supporting documents, looking for keywords to categorize them. For instance, if you submit a copy of the applicant's birth certificate, the system searches for keywords like birth certificate. If it can't locate those keywords or identify the document, the case may be automatically denied. USCIS's reasoning here, of course, is to save time and resources. I think it's reasonable to expect applicants to submit complete, organized packets rather than disorganized or incomplete submissions. However, this is where things get murky. I've witnessed situations where an applicant sends everything required, but during the pre-processing at the lockbox facility, USCIS loses a piece of evidence or a supporting document, or a page gets jammed in the scanner and doesn't make it into the file. It's then deemed lost. Was that your fault? No. But USCIS may treat it as if it were, which is actually a topic for another video I'm working on soon. In situations where USCIS loses evidence, it would be unfair to deny the case outright. That said, this isn't a reason to feel discouraged or panic. This memo does not mean USCIS will stop issuing RFEs and NOIDs altogether. Your responsibility as an applicant is to provide as much evidence and all required supporting documents with your initial filing. If USCIS has additional questions, they can still send an RFE. I can see that happening, for example, if you submitted all required documents for the I-130 and evidence of a bona fide relationship, but the officer found the relationship evidence weak or unconvincing, they might issue an RFE for more proof. Or perhaps you've already attended your green card interview and they now need further information from you. I hope you found this video helpful. If you did, please give it a thumbs up. Subscribe to my channel if you haven't already. Let me know in the comments if you have any questions, thoughts, or concerns. And I hope to see you in my future videos. Bye.